Right now, thousands of green card holders are boarding international flights with zero idea they could land back in handcuffs, not because of anything they did wrong at the airport, but because of a Supreme Court ruling 3 weeks ago that most immigration lawyers are still scrambling to explain to their own clients. If you have a green card and any kind of pending criminal case, hit pause right now, because what I'm about to tell you could be the difference between a normal trip home and getting detained at your own arrival gate. Alright guys, let's talk about this recent Supreme Court decision that impacts the rights that permanent residents have after they travel internationally and try to re-enter the United States. I do have my phone for this one, with some notes that I took to help me guide this video. But what I want to start with is what this decision doesn't do. It doesn't mean that customs officers can just deport you from the airport. It doesn't mean that they could take away your green card permanently or remove you from the United States. But what it does mean is that they can now treat a permanent resident as an applicant for admission to the United States and place you into removal proceedings or even detain you, which depending on what the criminal issue is, you may not be detained for very long. You might be released on bond pretty quickly. And this only impacts people who have a pending criminal matter or some suspicion that this person has been engaged in some sort of criminal situation. So they no longer need clear and convincing evidence, which would ordinarily mean a conviction, a final conviction. A mere accusation, which is like an arrest or a charge or possibly even something lesser than that. The Supreme Court decision wasn't super clear on this. A mere accusation, though, could be enough for customs officers to place you into removal proceedings and treat you as an application for admission when you enter the United States. So let me put a name and a date to this, because I think that actually helps you understand why this matters so much. This is the case of Blanche versus Lau, decided by the Supreme Court on June 23, 2026, in a 6-3 vote. Justice Clarence Thomas wrote the majority opinion, joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett. Justice Ketanji Brown Jackson wrote the dissent, joined by Justices Sotomayor and Kagan. The case involved a man named Muk Choi Lau, a Chinese citizen who became a lawful permanent resident back in 2007. In 2012, he was charged in New Jersey with trademark counterfeiting. While that charge was still pending, before any conviction, he traveled to China and then tried to come back into the U.S. At the airport, a border officer decided not to treat him as a returning resident and instead paroled him into the country while his criminal case was still unresolved. He later pled guilty, and the government used that guilty plea to place him into removal proceedings, arguing he had actually been inadmissible the moment he tried to re-enter, even though there was no conviction at that point. Lau fought this all the way up, and the Second Circuit actually sided with him in 2025, ruling that the government needed clear and convincing evidence at the border before treating him that way. The Supreme Court disagreed and reversed that. An example of this would be you were charged with some sort of theft offense, and let's say you didn't do it. It's a mistaken identity, right? You travel internationally, you re-enter the U.S., and the charges are just pending. You hire a lawyer who said he's going to clear it right up, and he thinks it's going to get dismissed. Well, ordinarily, in the before times, customs officers would need a final conviction for this arrest to prejudice you, to create major problems for you, or to result in you being deemed inadmissible and placed into removal proceedings upon trying to re-enter the United States. But that's no longer the case. A mere charge can be enough. If there's some suggestion, if the officers believe that you committed the crime, they can now, without clear and convincing evidence, place you into removal proceedings. They can, in some scenarios, even detain you, and then you have to deal with being detained upon re-entering the United States, and hiring a lawyer and defending yourself in removal proceedings. And just so you have the exact legal language for this, because I think it actually matters if you ever end up in this situation, Justice Thomas wrote that the Immigration and Nationality Act only requires a reason to believe that a qualifying offense occurred, not clear and convincing evidence. That's a significantly lower bar than what several lower courts, including the Second Circuit, had been requiring for years. And to be clear about what kind of offense we're talking about here, this whole framework revolves around something called a crime involving moral turpitude, or CIMT for short. That's a legal term that generally covers things like fraud, theft, dishonesty, forgery, perjury, or certain violent offenses. Congress has never actually defined it with precision in the statute, so courts have had to work it out case by case over the years, which honestly is part of the problem, because it leaves officers with a lot of discretion in the moment. Now stay with me here, because the next part is the piece almost nobody is talking about, and it's honestly the scariest part of this whole ruling. Quick side note here. If you are detained, I made another video on this, but it bears repeating. An immigration judge can conduct a bond redetermination hearing to see if you're eligible to be released on bond. The judge will typically consider two main factors: whether or not you're a flight risk, unlikely. If you're a permanent resident, you probably have strong ties to the United States. And two, whether you are a danger to the community, which is going to largely depend on what the police report and other factors in the case, even though you don't have a conviction yet, say. So, you can be detained, but in most scenarios, unless the charges are incredibly serious, I would expect permanent residents to be released on some sort of bond, or not even have to see a judge. ICE can just release you on your own recognizance in some situations. They're less likely to do that now than they were previously, but most permanent residents in this scenario are unlikely to actually be detained. The more likely scenario in this theft defense situation is you'll be placed into removal proceedings upon re-entering the U.S., and then, if your criminal matter is cleared up, you can most likely just terminate those removal proceedings through the assistance of an immigration attorney. I also want to flag something that a lot of the legal commentary on this case has picked up on, which is the difference between being admitted versus being paroled at the border, because that distinction is a bigger deal than it sounds. If you're readmitted as a returning resident the normal way, the government has to carry the burden of proving you're deportable if they ever want to remove you later. But once you're classified as an applicant for admission and paroled in instead, that burden can shift onto you to prove your right to remain. And in some cases, officers can even hold onto your physical green card while your case is pending. Some immigration attorneys who reviewed this ruling described it as giving border officials, quote, almost unlimited discretion over returning green card holders. And in her dissent, Justice Jackson didn't hold back either. She wrote that the majority had handed the government what she called a massive blank check, and she pointed out what she saw as a sequencing problem, meaning the officer is supposed to decide whether you committed the crime at the moment you're standing at the border, and it doesn't really make logical sense to let a conviction that happens months or years later retroactively justify that on-the-spot decision. Alright guys, so a couple practical implications here. If you have a pending criminal matter, you might want to rethink traveling internationally as a permanent resident until that's been fully cleared up. And travel with a certificate of disposition in your hand, showing that the matter's been dismissed, or that the outcome does not rise to the level of a crime involving moral turpitude or some other inadmissible offense. You're going to want to speak with an immigration lawyer before you travel internationally. If you have a criminal matter pending, or if you've been convicted of something that might rise to something that renders you inadmissible, even if you have a minor criminal matter under state law. I can't tell you how many times people have said, "No, that's not a big deal. I don't need to disclose that because it's been resolved." It can be a big deal under immigration law, even if it was not a big deal under state law. So, just be careful. I've seen some situations where people end up in removal proceedings even though the matter has been fully resolved and their attorney told them that it wasn't a big deal. That was a criminal defense attorney. That was not an immigration attorney. And here's the part that catches people off guard the most, so pay close attention if you've ever had any run-in with the law, even a small one. And honestly, this ties into something I keep repeating on this channel, which is that criminal defense attorneys and immigration attorneys are looking at completely different rulebooks. A plea deal that looks great on the criminal side, maybe it avoids jail time or gets you a lighter sentence, can be absolutely devastating on the immigration side, especially now that even the accusation itself can trigger this kind of scrutiny at the border. So if you're a green card holder and you're in the middle of any kind of criminal case, please don't sign anything. Don't accept any plea agreement without running it by an immigration attorney first, even if your criminal defense lawyer says it's fine. Those are two different questions with two different answers. And finally, this only changed the procedural situation for green card holders, permanent residents who've been charged with a crime. If you haven't been charged with a crime, This actually changes almost nothing for the vast majority of permanent residents. So, like there's a lot of fear-mongering out there. If you've been relatively law-abiding and you've never been charged with a crime, this isn't really something you even need to worry about. I wouldn't be super concerned about traveling internationally, as long as you limit how long you spend outside of the US. You make sure you maintain a permanent residence in the US, so there's no allegations that you're not living in the US permanently or you've abandoned your residency. Short departures, which I would generally define as like sub-90 days, fewer than 90 days outside of the US, as long as you're not leaving the US for 90 days, only coming back for 30, leaving again for 90, 30, like keep doing that, could be problematic. Because in the totality, if an officer looks at your travel history, he might say like, this person clearly isn't living and working in the United States, which is actually a requirement to be living here permanently if you want to be a permanent resident. So, outside of criminal issues and abandonment issues, I tell my permanent resident clients to enjoy their trips abroad, like there. Don't let all the fear-mongering out there dissuade you from a short trip outside of the US unless you have a criminal matter pending or some other major issue where they could deem you to have abandoned your permanent residency. It's also worth knowing this decision didn't happen in a vacuum. It lines up with a broader push towards stricter border enforcement that we've seen out of this administration over the past year or so. And immigration attorneys have been telling outlets like Newsweek that this ruling fits squarely into that trend, giving border agents more room to act on suspicion rather than proof. So if you've been reading headlines about tighter enforcement at ports of entry lately, this Supreme Court decision is one of the legal pieces that's actually making that possible in practice, not just in policy talk. That's part of why I wanted to break this down clearly for you today, instead of just letting you piece it together from scary headlines. Anyway guys, just a short video on this topic. I didn't do a line-by-line of the Supreme Court decision like I did in some of my other videos, but I hope that just the general take of this helps some people out there. Bottom line, if you're a green card holder with a clean record, live your life, travel, don't stress. But if you've got anything pending, even something you think is minor or a total misunderstanding, get in front of an immigration attorney before you book that ticket, not after you land back in the US and get pulled into secondary inspection. That one conversation before you travel could genuinely be the difference between hugging your family at arrivals and being pulled into a back room for questioning. And if you're new to my channel, and this is the kind of straight talk breakdown you actually needed instead of another scary headline, be sure to subscribe right now, because I'll make videos on all the newest immigration changes the moment they happen, and I'll see you next time for another video.